Aloha mai kākou. My name is Brianna Govea. I'm the Curator of Collections and Programs here at the King Kamehameha the 5th Judiciary History Center. I want to mahalo all of you for joining us in the middle of your work day for this very important discussion. Mahalo to Acting Chief Justice Sabrina McKenna, the Hawaii State Judiciary and Legislature for providing space for us to gather here in the beautiful Supreme Court courtroom and to host an important conversation about the state's proposed public-private partnership to build, design, and maintain a new jail on Oʻahu. While the Judiciary History Center hosts diverse discussions, the speaker's remarks do not necessarily represent opinions of the Hawaii State Judiciary. Friendly reminder that this program is also being recorded, and mahalo to our great audience right now gathering on Zoom. The recording will be posted on the History Center's YouTube channel tomorrow at JHC Hawaii. I encourage our Zoom attendees to submit questions to our panelists using the Q&A function at the bottom of your webinar screens. I also want to mahalo our program partners at the Hawaii Friends of Restorative Justice and Hawaiʻi Community Safety Coalition for collaborating on this event. And I'd like to welcome Lauren Walker of the Hawaii Friends of Restorative Justice up to the podium.
Hello, thanks, and sorry about last week. The electricity went out, so we couldn't have it. But I'm here to introduce Liam Chinn, who's going to facilitate the panel. Liam has 20 years experience in safety, doing safety initiatives and policy for safety for communities. He's done restorative justice work, and he also is a graduate of the University of Chicago. He has a master's degree. And he also, I think, has a unique perspective being raised on an Alaskan Native community. And he also is, if anyone's ever talked to Liam on the phone for over 20 minutes, he is the hands-on father of twins, baby twins. And he's a great facilitator, and we're thrilled he can be here today. Thanks.
Thanks so much, Lauren and Brianna, and thanks for hosting us today. It's wonderful to be here together, and thanks for everybody for taking your lunch hour. We'll try to keep it short and informative, and but with that, let's get started. I want to start again with just a brief introduction. I'm going to give you about a 5-minute introduction because I think it's important to contextualize the conversation today, because there's a lot around it that will help you as these amazing panelists step in to understand kind of where the issues lie. So the state of Hawaii has put forward a proposal to replace the Oʻahu Community Correctional Center. The proposal is for a new expanded bed facility, approximately 1,300 beds at a starting price tag of roughly $1 billion. The facility would be delivered through a public-private partnership, also known as a P3. Specifically, the state is proposing what's called a DBFM model, design, build, finance, maintain, where a private sector partner would take on those functions on the state's behalf. The state would retain responsibility for operations of the jail, including custody and functional services through the Department of Corrections and Rehabilitation. Under this model, the state would partially fund design and construction. A private entity would finance the remaining costs. The state would make payments over a 30-year period for financing and maintenance. And the private entity would maintain the facility for those 30 years. The projected timeline for this project is approximately 6 years, with the most optimistic estimate an opening in around 2032. Though timelines for projects of this scale in Hawaii, as we know, often extend beyond initial projections. Because the legislature has not been willing to fully fund a new jail up front, the state's primary rationale for this P3 model is that it allows the project to move forward without the required upfront public funding, while relying on the assumption that private delivery may improve efficiency and transfer risk from the state to the private entity. A quick clarification, this comes up a lot. What is the difference between a jail and a prison? We're not talking about a prison here, we're talking about a jail. A jail is generally a short-term facility holding people awaiting trial or serving shorter sentences, most often for lower level nonviolent offenses. I just want to make that distinction. Okay, let's get into the key context here. So while the state believes that a larger jail will improve outcomes and reduce costs, some public safety experts and community members disagree with that assertion. And we're going to talk about some of those areas of disagreement today. It is important to note, though, that those raising concerns about the new jail, they do agree that the current conditions inside OCCC are unacceptable and that they must be addressed. What they question is whether building a new, larger $1 billion jail that is financed, built, maintained by a private for-profit entity is the right solution. One key issue that has been raised by these experts and members in the community is who is currently in Hawaii's jails. 2024 and 2025 data from the Department of Corrections and Rehabilitation Intake Services Center indicated that at least 37% of people in jail are experiencing homelessness. Intake Services Center also noted that that number is likely higher. Again, that's 2024, 2025 data statewide. In addition, the Hawaii Correctional System Oversight Commission has found that a significant portion of the people in Hawaii's jails are suffering from mental illness and or substance addiction. The Department of Corrections officials themselves have acknowledged that a significant portion of the jail population could be safely managed in a community-based setting. Director Johnson himself has stated at a public safety committee hearing last year that we have people in our custody who should probably be on supervised release in the community. We're spending approximately $307 a day to keep people in custody who may have only a $50 bail. And he noted that jails are often the least effective, most expensive place for individuals with mental health needs. Those opposing the current proposal also point to a lack of independent analysis and alternatives to expanding jail capacity. They note that Hawaii's population has declined in recent years and that the 2025 population here in Hawaii is actually lower than it was 10 years ago and continues to decline. But more immediately, they argue that the potential for diversion has not yet been fully realized, and that the system may be able to reduce the number of people entering jail through policy and practice changes, as well as bail or pretrial reform. In recent years, Hawaii's justice system actors, police, prosecutors, public defenders, judges, and service providers have been working together to identify ways to reduce incarceration safely. There's a growing consensus that diversion to housing and services can significantly reduce the jail population, lower recidivism, and save public resources. Given this context, those raising concerns about the current proposal have called for a right-sized solution for OCCC. The state, on their end, has contended that any new facility must be built based on today's needs. The numbers today is what should determine what facility is built. Yet, the facility itself is only one part of the solution to OCCC. The Hawaii Correctional System Oversight Commission has called for a pause in jail planning in a letter to the governor. In calling for the pause, they cited concerns about the Department of Corrections and Rehabilitation's failure to implement recommendations related to rehabilitative programming and healthcare. The commission's position was clear: a new facility alone will not resolve systemic issues. Finally, even at the highest levels of decision-making in our state, there's a tension between the current proposal and the direction that reform advocates are pressing. In June of 2025, Governor Green stated publicly that any new facility that is built will be smaller than the current facility and would be treatment focused. And he also stated that that he was exploring purchasing the federal detention center as a replacement for OCCC. Despite calling for a smaller facility and the proposal for to purchase the federal detention center, the current proposal for an expanded 1,300 bed facility at an estimated cost of $1 billion remains the only proposal on the table. Okay, so with that said, there are many questions that remain unanswered, as you can see. The purpose of this panel is to explore those questions and to examine whether this proposal best serves the long-term interests of Hawaii's communities, taxpayers, and the justice system. Our panel today includes voices with direct experience across the spectrum of this public policy issue, and I'd like to quickly introduce them. Carrie Ann Shirota is a civil rights attorney and public policy advocate who has studied for-profit prisons and incarceration. Eric Seitz is a civil rights litigator whose work has advanced accountability in the correctional system. And Jim Richardson taught as a University of Hawaiʻi business professor for 30 years, where his research has evaluated the economic costs of recidivism in Hawaii's correctional facilities. Together, this panel brings legal, policy, and business expertise to bear on the proposal's risks, costs, and potential benefits. Focus will be on what best serves the long-term interests of Hawaii's communities and the justice system. Okay, with that said, I want to just jump straight into the questions here. So the first question is for you, Jim. Supporters argue that a P3 delivers value for money. If the private sector's cost of capital is inherently higher than tax-exempt public bonds, what is the mechanism, at least theoretically, by which a P3 becomes cheaper?
Well, the question is, how can a private company borrow the money cheaper than the state? The state can finance things cheaper than most private companies. So if the proposal is for a contract where the private party is doing the financing, the question is, how do they do that cheaper for the state, right? This raises one of the concerns that people raise all the time with P3s around the world, which is that we may never know how the private party saves money and how much money they make, because a lot of that remains confidential and proprietary, how they do things. So that is a difficult question to answer precisely. But what they argue, there's a number of different ways that they argue they can save money. One of those is just by integrating the design and the build together. They can be more efficient in both steps, and they can reduce the risk, like risk of change orders and that sort of thing. So that's one place where they argue they can lower costs for the state. Another is that they'll do better maintenance. They're basically building in to the contract guaranteed maintenance at a certain level, which can lower the long run costs. So that's another way they go about it. They generally argue that there are stronger incentives for the private party to reduce costs because of the nature of the contracts. And one of the ways that could show up is through innovations in the way the contractor proposes to do the build and the maintenance and that sort of thing. So those are all kind of the case they make for the potential of lowering costs. If you look on the DCR website, the Department of Corrections website, they have posted a slide deck with an audio presentation next to it, which goes through the argument and the case for using this type of contract, this DBFM P3 contract, and all the benefits, the greater value for money that you're going to get from it. If you're interested in pursuing that deeper, that's a good place to start. One thing you can be sure is that the private contractor expects to make a profit. So whatever happens here, that's part of their plan. And interestingly, CoreCivic, well, first of all, it's likely that the bidders on such a contract are going to be private prison companies because they're the ones best positioned to do this. I mean, there have been cases where other types of contractors get involved, but it seems pretty likely that they're going to be private prison companies because they have the knowledge and they have the capacity to finance something this big, or at least to raise the financing. So that's pretty likely. And if you look at the CoreCivic annual filings and statements that they put out, what they've targeted this DBFM kind of contract as an opportunity. because they recognize that there's been a lot of concerns and problems with privately operated prisons. So if you take the private operation out of the scheme, it kind of skirts a lot of those issues that people have with private prisons and still allows them to be in the game. So they've really targeted this DBFM as an opportunity that they want to grow. The evidence, if you look at the literature on P3s in general, is that sometimes they do reduce costs and sometimes they don't. It's kind of a mixed bag. We'll talk more a little bit about under what conditions it can be cost saving. But generally the evidence is that it's mixed.
Thank you for that summary. Very helpful. So I'm going to ask you a quicker question that's kind of a follow-up to that, just so we make sure at the front end we're focusing on the model and the proposal. So most P3s actually, as it relates to correctional facilities, usually they involve the private entity also operating the facility. So you hear a lot about private prisons and jails, but that in this scenario, the DBFM, the private entity is not going to be operating the facility. Again, it's design, build, finance, maintain. So that's what's being proposed here in Hawaii. I'm wondering what evidence beyond theoretical modeling supports this approach in Hawaii, given that this is not the typical type of partnership where there's also operating of the facility. And what guarantees can the state make that it will perform as expected here?
Guarantees. Well, yeah, the research shows that private prisons aren't generally less costly than public prisons. The amount that the states or the public entity ends up paying for private incarceration ends up being about the same, sometimes a little higher, sometimes a little lower. And this is not that. So this is not a privately operated prison. It's publicly operated. So it's a little bit different animal, a different model. And there isn't much experience in the US with these DBFM contracts, especially for jails and prisons. Internationally, there have been cases of P3s with DBFM contracts, including for jails and prisons, that have had some success. So it isn't unknown in the world, but it's relatively unknown in the United States. The only example I could find is the Lansing Correctional Facility in Kansas, which was done with CoreCivic under one of these DBFM contracts. And the history of that was sort of interesting. What happened was the contract was under consideration in 2017, and the state decided to audit the contract because I guess they were concerned about the contract. And the state auditors concluded, after looking at the contract, where they were able to see some of this private and confidential information, they concluded that the contract would have been more expensive than just having the state finance it and doing a design build contract with some entity, and then later doing a maintenance contract with some entity. So that was what the auditor concluded, that the DBFM contract would have been more expensive. And the state went ahead with the contract anyway, the DBFM contract. So the experience over the next couple of years revealed that the construction costs were over what they were projected to be, and the total savings to the state entity ended up being something like 1.3 million over 20 years, as opposed to the original plan of 23.6 million. So again, you know, it's kind of a mixed story in terms of the cost savings. So that facility was completed in 2020 and it's now in operation. So it's operated by the state, but it was built, financed, designed, built, financed, and maintained. So that's been around for 5 years.
Thank you. So just to summarize, if we're understanding, it's a relatively, DBFM is a extremely rare in the U.S. It's been seen internationally.
It's the only one I could find.
Okay, so we have one example in the United States ever.
I had one more point to make about this.
Okay, yep, go ahead.
In the world of business, well, the proponents of the DBFM contract basically claim that it's going to be better, faster, and cheaper to use a DBFM contract than to do the traditional thing. And that sort of raises eyebrows in the business world, because generally in the business world we'll say, Yeah, pick any two of those. Okay, you're not going to get all three. So that's kind of a red flag.
Gotcha. Thanks. So that's helpful contextually. So the state would be sort of stepping into the unknown to some degree, it sounds like, just because this Lansing, Kansas was the sort of the only case study we could find. And this model does exist internationally, but trying to transfer those lessons here is obviously problematic for a number of reasons. That's helpful. I want to move us forward into some other aspects of the debate now that we have a sense of the sort of the model and the context for it within the industry. This question is for Eric and Carrie Ann. At what point does delegating the design and long-term maintenance of a jail to a for-profit entity raise fundamental concerns about whether the state is appropriately fulfilling its moral and constitutional responsibility for the people it incarcerates versus outsourcing that responsibility to actors whose duty is to shareholders rather than the public? And again, this relates specifically to the design and the long-term maintenance, understanding the operations are not happening. So Eric.
Well, you know, I've been involved in prison litigation for 40-some years in Hawaii. Actually, maybe even longer than that. And I've done several class actions. And the purposes of those cases is not to make money for anybody or get damages. The purpose is to get attention to the fact that we treat people in these institutions atrociously. We don't solve any social problems by locking people up under the conditions that we do, and that hopefully public opinion can be affected positively to demand that we do a better job. Mr. Johnson and I have had this conversation several times. I'm not looking for damages, and very often when I sue him, what I'm trying to do is get the legislature to appropriate the money so he can do the job that he'd like to do. But the legislature consistently refuses to do so because the people in the state of Hawaii are not outraged about what's going on in the prisons. They just simply don't care. You know, they'd rather just lock up Hawaiians in disproportionate numbers. They'd rather lock up homeless people because that way they're off the streets. They'd rather keep people in jail who can't afford to post bail. That's the public opinion that's prevailing in the state of Hawaii. And until and unless that changes, nothing is really going to change fundamentally with respect to how we treat people who are either subject to mental health treatment or who are locked up in prisons. So it's even more distressing in my mind that we're going to delegate these moral decisions to private entities that are basically cost and profit driven, because they don't care about the welfare of the people. They only care insofar as that affects the bottom line, and they don't care about what the social outcomes and impacts are from locking people up who don't need to be in jail or need to be receiving care elsewhere. So whenever we make a decision to bring in a private entity because it's cost effective or bureaucratically conducive to getting a building built or staffing a new facility, what we're doing is basically passing the moral obligations on to some company that isn't necessarily in any position to address those issues. And we're abdicating our responsibilities altogether. And, you know, again, Tommy and I disagree about a lot of things, but I think it's important. There are a lot of good people who work in the corrections industry. I know many of them. And to the distress of Mr. Johnson, many of them talk to me directly and tell me what's going on. And, you know, we would like to be able to enable those people to do a good job. So, for example, when COVID broke out, the governor made, the soon-to-be governor, then lieutenant governor, made some snotty remark about being in prison was probably the safest place during the COVID epidemic. He later regretted that deeply, because it was a horrible place, and COVID spread through the institutions horribly because they had no place to isolate people. They had no way to treat people. And we filed a class action to try to bring experts in from outside who had experience to be able to assist corrections people in controlling the epidemic. The state, the Attorney General, fought that lawsuit. Basically, all we were doing was trying to compel the state to set aside the resources to help the Department of Corrections understand what was going on and try to fix it. And the Attorney General's office fought that. Eventually, we got a decision from a federal judge that was pretty devastating. We brought in the experts, and the prison was able to control what was going on and being able to approach it in a far more systematic manner than what they'd previously been able to do based upon the advice and recommendations of those experts. Similarly, more recently, we filed a lawsuit based on the number of suicides and the lack of appropriate mental health care in the facilities. The state fought that. Everybody knows that there are serious problems. And the AG fought that case, up one side and down the other. But eventually, with Mr. Johnson's help, we settled that case, and the resolution was again to bring in 2 nationally recognized experts to help the corrections people design approaches to be able to resolve the shortcomings in providing mental health care in the system. Now, that's just one part, because we need facilities, we need hospitals, we need placements in the community. A lot of people who are in prison who have mental health needs shouldn't be in prison because they can't get what they need there. But the approach is to deal with the underlying moral issues and ethical obligations to provide care, decent care for people, as opposed to just locking them up and forgetting about them. And that is, unfortunately, the prevailing view of many people in this state, including many people in the legislature. And until that changes, just simply bringing in some private entity to address the needs of how we're going to lock up people is only going to make things worse.
Thank you. That's a helpful overview. Carrie Ann, did you have anything you want to add to that?
Yes, so I just want to take a step back, because I think there's been this assumption that constructing a new jail, it's a foregone conclusion, that the train has left the station, but there's still time to stop this ill-conceived project. First of all, we need to point out that this would be the largest proposed public works project in the history of Hawaii, which is incarcerating our people, predominantly Native Hawaiians, in their native lands. Second, there's been a lot of arguments that this is the compassionate thing to do. But what's compassionate is to invest in diversion systems that will reduce the number of people who are locked up, removed from community and family. More investments in pretrial population will reduce the number of people who are being funneled into a system who are legally innocent and not convicted of any crime. And we also have a large percentage of people who have probation, a violation, and instead of working with them in the community to get the support they need, they're put back in jail. So if we were to collaboratively invest in these data-driven solutions, we could significantly reduce the number of people, not only at OCCC or all jails throughout Hawaii, and there would be no overcrowding. And then we need to address if there are ADA violations and other potentially renovations, but we should not just accept this belief that we need to construct this new jail as part of this industrial complex. There has been no evidence in Hawaii that this type of scheme has worked. The closest we can look at is rail, which started off as a P3. And I think we all know that that has gone over budget, over time, and we're seeing the maintenance falling apart even when it's not completed. So do we proceed on an experiment of a scheme which has never proven to work in Hawaii, and especially when it comes to locking up people? It might be different if we're pursuing a P3 and it's a bridge or a road, or maybe even presumably someone could argue the stadium or a concession stand at the airport, because I think they pursued a P3 or a model of it. But that's a revenue generating facility, the airport. Should we maybe making money off of the profits of people who are incarcerated? Absolutely not. And so I just want to add that even though it's been sold to the community that we are not going to have the private prison operators, profiteers, to operate the jail or prison. If you look at the history in some other states, they have bought out other public prisons or jails. It is not only an industry to detain people on the jail side or long term, but also we see an industry that's profit driven that are benefiting the shareholders of these corporations, namely CoreCivic, where we are exporting our people to for-profit prisons on the continent. And now to increase their profit, they have looked to expand their contracts to detain immigrants, parents and children. So we need to ask ourselves as taxpayers that will ultimately pay the price and future generations, do we want to invest our taxpaying dollars into a system and into companies and to shareholders who could care less about our community and what builds safe, thriving, healthy, and just communities?
Thanks for the overview. And we are going to talk about diversion and alternatives more in a minute. But I want to dig in a little bit more on the kind of technical side here as we talk about the design and the maintenance components. Well, obviously, we talked about custody remaining in the hands of the state. The conditions of custody, the built environment, would be privatized. So when you think about the design, the way something's designed could impact the health and well-being of those incarcerated. When you think about the way something is maintained, that could impact. So even though it's not direct day-to-day operations, so I want to dig into that. So under the DBFM model, the private partner profits by controlling costs over decades. And we already see how deferred maintenance leads to unsafe conditions, even under the state control of the state at the moment with OCCC. Severe infrastructure deterioration at our existing facilities. What evidence shows that a DBFM model, P3 DBFM model would prevent rather than replicate these current failures we see under state control? Let's start with Jim and I'll go through here. So, yeah.
Okay. The idea is that in the DBFM contract, the maintenance is pretty carefully specified, and the contractor is obligated to maintain it to that specified level. So that's supposed to make sure that that kind of thing doesn't happen. Why that happens in the case of the privately operated prisons probably has to do with the fact that they're privately owned and operated. And so they can defer maintenance just like anybody else, and then conditions deteriorate. But in the case of the contractual arrangement in this story, it looks like, as long as you specify the contract carefully and you monitor it as well, you can avoid such things. So those actually in the literature are two of the key success factors with making one of these models work, is that you have to have a really well specified contract with all the performance specifications, and the state has to really monitor it to make sure that's happening. So that's how they try to alleviate that.
Okay. So if I'm understanding, the state pays the private entity upfront essentially for the maintenance, 30 years, and that's the incentive for the.
Well, they don't pay it all upfront,
right?
But
it's in a contract.
Yeah,
it's good. Yeah, it's
so they can't just say 1 year, well, we're going to save money on maintenance this year.
Right. So in defense of folks at DCR who have to depend on the state's yearly swings in budget, would it be safe to say that through this contract a more stable amount of funding would be earmarked for maintenance over that 30 years, or could it change?
My understanding is that it cannot change, that it's part of the contract up front. So there might be some flexibility in terms of what the maintenance costs are, depending on the population in the prison, or in the jail. So if it was reduced by half, maybe the maintenance goes down. I'm not sure how the contract reads, but they're committing up front to maintain it at a high level that will maintain the facilities, better than our typical maintenance.
Understood. Carrie Ann or Jim, can you talk about the ways that that a jail facility might be designed and maintained when there's a profit incentive, to control costs? How might that actually look and manifest? You talk about the issues we saw with, I think it was Saguaro with tainted water and so forth. Again, that facility is also operated by a private entity, but that related to the infrastructure. Can you talk about the way the built environment and the maintenance, so let's start with Carrie Ann, could potentially affect the health and safety or the conditions for those who are incarcerated?
Sure, I think ultimately private prison corporations are going to look for the biggest profit. And so if there are ways to cut corners with design construction, they're going to take it because it means more ultimately profit. When we look at Saguaro Prison, which was built specifically to export our people in Arizona, I actually visited with Director Johnson and a number of other senators when it just opened up. And shortly after it opened up, it was being pitched as the state-of-the-art prison. And if you went in there, it just looked like prisons, bars, typical, but it was pitched again as state-of-the-art. And shortly within that period of time, I remember that there were problems, I think, with maybe the showers and things overflowing. Over the years, a few years ago, I reported, people had called reporting issues with the sewage. And also, as you know, the ACLU sent a demand letter relating to tainted water at Saguaro. So I think all of these things are going to come up under a P3 model, and that needs to be considered. But I just want to point out the design aspect, because this is a big part of this quote P3. Despite the fact that this new jail is being pitched as compassionate and state-of-the-art, and that it's going to focus on rehabilitation and corrections, this design is still trauma-inducing in general when you remove people from the community and their families. But I attended a presentation by the DAGs, and I forgot the gentleman's name. And he had mentioned at an informational briefing that when you put out a P3, that the private, essentially company, that up to 60%, that they essentially can dictate 60% of the design. So even though we're talking about holistic and rehabilitation, if they can control 60% of the design, you can have 60% of the design to look like Halava and OCCC to cut corners and cost. And so I think we need to, again, be very careful with what we're being sold and what the reality of this P3, what the outcomes will be adversely to our community.
Thanks for that. And I think some of the rehabilitative and sort of culturally grounded design that you refer to came from the UH Design Center's report, which was quite expansive and had a lot of really forward-thinking ideas in it. And, they did hold a number of community engagement sessions. I encourage people to look at the UH Design Center's report. I think it sounds like the concern you have is, well, that's on paper. It actually being implemented may ultimately be in the hands, that discretion is in the hands of the private entity who seems to control more of the design process. And of course, ultimately, there's the cost concerns. With that said,
Could I add something to that?
Yeah.
Yeah, that's an important point because, as I said, it's likely that these private prison companies are going to be the bidders on this. And the most efficient thing for them to do is to use designs and construction methods that they've used before, because that's what they know. And so that's what we're likely to get.
Yeah, that makes sense. Jim, quickly, do you have anything to add as it relates to the design and maintenance of facilities and the work that you've done? Can you give me some examples of the way that can sometimes fall short, and what is the impact on the folks in custody?
You're asking.
I'm sorry, no, Jim, my mistake.
no,
Eric.
Well, I kind of disagree with some of the things that have been said, because in my experience, the degree to which these private companies are responsive, you're always going to have maintenance issues in facilities. I mean, you can't avoid that. But at least with respect to Saguaro, in my experience, when there has been a problem, I'm able to get a hold of the people in the department here who have the relationships with the people in Saguaro, and they have always been responsive to make demands on Saguaro to address the issues and the concerns that I've raised, because that's what they do, and they're very conscientious about it. Now, contrast that, yes, you'll read in the next day or so about a lawsuit that we just filed for a suicide that occurred in South Carolina at a facility used by the Department of Health to send people that they apparently can't treat here at the state hospital. And what happens there is just simply atrocious, because the Department of Health sends people up there and doesn't monitor what happens to them after that. And so we've had 2 suicides out of, I think, 12 or 14 people that we've sent to South Carolina. That place is an atrocious institution. But the problem is we send people there, and then the Department of Health just basically forgets about them. Now, that's a problem with government bureaucracy, which is a perpetual problem in a whole bunch of departments. It ebbs and flows. The supervision of these kinds of programs that we contract with ebbs and flows depending upon the money that's appropriated to these departments and the staff that they hire and the aggressiveness that those staff utilize to be able to fulfill their obligations. And so, if we put people in the hands of a private institution and we don't hire the staff to monitor what that institution is doing, forget about it. I mean, it's going to be a horror show, as we now see in South Carolina. And that's my concern.
That's helpful. And we're going to come back in a bit about the contract itself and the transparency and, the ability of where the accountability lies. Carrie Ann, I want to turn to you. Before committing to $1 billion plus facility, what does the research say about alternatives like pretrial reform, diversion, and treatment in reducing jail populations and costs? And if the same level of investment, $1 billion plus, were to be directed towards supportive housing, behavioral health, and other diversion infrastructure, what outcomes would we expect to see instead?
Well, there's no comparison. I mean, there's seminal research that shows that investments in diversion, from pretrial reform to probation reform, all of these things are more cost effective and actually helps people, including mental health treatment, substance abuse treatment. And I think we need to really be pragmatic about this project, is that we cannot afford to build a $1 billion super jail and to invest in diversion infrastructure, pretrial, and a continuum of community-based care. We just do not have the resources, and so we have to make difficult decisions. And if you look at the data, community-based treatment is far less than the $310 we're spending per day, which when you multiply is $112,000 a year to incarcerate one person annually. And when you talk about a patient in custody who has complex medical care needs, on average, it's between $600,000 and $900,000 per person. So think about the ways if we shift those resources into the community. We have wait lists for drug treatment, mental health treatment, dual diagnosis. We have no wait lists to get into our jails. None. It doesn't matter how overcrowded, it doesn't matter how understaffed, we just shove them in there. And so we need to make a decision about the diversion. And I think we need to point out that a number of people who are entering our carceral system are houseless prior to and will exit to houselessness without robust support. And when you look at supportive housing, the recidivism rates and the cost of that, I'm so sorry, it's escaping me at the moment, but it's much less than the recidivism rates that if someone gets no treatment, no supportive housing. And so that on probation reform, there's a number of states that have passed laws to reduce the number of people who have entered back into jails because of probation violation, not because they've been arrested or convicted of a new charge, but because they have a violation. Maybe they missed meeting with their probation officer. Maybe they've tested positive for drugs, which brought them in. But why do we lock them up, warehouse them where they don't get treatment in jail? Again, it's the most expensive, least effective option, to quote Director Johnson here. And so we need to look at what works most effectively.
Very helpful. I think the numbers that I came across from housing, supportive housing providers was that there's over a 50% recidivism rate for those who exit jail and are not provided with housing. 50% recidivate, and it's only 12% for those who receive permanent supportive housing. And then the other number that I thought was fascinating was that, so we're paying $112,000 a year to incarcerate someone at OCCC, but to provide one person with permanent supportive housing, which has 24-hour wraparound mental health, drug treatment, and other services, is $30,000. So it's 112 versus 30. So that's interesting just from a numbers perspective, as if we evaluate public safety outcomes to consider. One other thing that had come to mind is you talked about the state not being able to afford both. So one note on that is I have heard that I think Public Safety Chair Bellotti once noted that the state can in fact invest in both. You know, she sort of countered this notion. She said the state can make investments in diversion infrastructure and reentry and pay for the jail. But in doing that, for example, she quoted a $4 million investment in reentry. So what struck me was scale. Throughout my 25 years of working in public safety, I've always said we've got a scaling problem where it's almost two different currencies. So on the one hand, we talk about $1 billion jail, and that's considered a normal price tag. But as it relates to diversion and housing and infrastructure, we talk in the low millions. So it's two different currency systems. So it really is an open question whether the state can afford both, and I'd like to hear more on that. But back to you.
I just want to add, I mean, if you look at the amount of money that's been spent just on the planning and design of this jail, let alone on Maui, we can get into Maui. They spent $15 million to build the jail that the community said, no, we want to invest in alternatives. So over $15 million was spent on Maui, no jail, and they have managed to decarcerate and reduce the number of people without in building a regional prison complex on Maui. And that was because that reflected the sentiments of the community. This jail, according to Honolulu Star Advertiser, over the course of period, they've been spent about $55 million. And right now, as we speak, the Department of Corrections is asking for $15 million more this year to continue with this planning and to put out the RFP. I mean, that's the latest I saw. Things are moving rapidly at the legislature, so forgive me if it's not up to date as of today. Another $15 million. Can you imagine the supportive housing, the treatment we could provide for people with that in place? And I did not speak to pretrial reform. I'm so sorry. That's like the elephant in the room. When we look at OCCC at any given time, there's 60 to 70+% of the people there who are pretrial status, meaning they haven't been convicted of a crime. If you look at other jurisdictions in both Republican and Southern states and jurisdictions, so this is a bipartisan issue, criminal justice reform. They have reduced their jail population on low end, 20, 30%, up to 70% for a fraction of the costs. And the money saved from incarceration is put into things like supportive housing, treatment. If someone has a positive test, they might not be able to get in even if there's a space to get into treatment because they may not have the money to do the substance abuse assessment. So see, we're spending on the most expensive, but instead of looking at prevention and helping people to be thriving and successful in the community. And so pretrial reform, unfortunately, there was a bill that would have reduced the number of people in our jails statewide. Unfortunately, it lacked the votes and it died on the Senate floor, but we cannot give up. We need to invest in pretrial reform because it's a proven way to reduce costs. And most important, in states from Harris County, Texas to Illinois to New Jersey, et cetera, they've also had reductions in crime. So for all the people that are the tough on crime rhetoric and say, we can't invest in pretrial reform or bail reform because the people are going to be running out and committing crimes, the evidence from scholars and academics from Harvard University across the board, that has not been evidence. So that's rhetoric, and we need to interrogate that because that's the dominant narrative that's factually untrue.
Thanks for that context. I'll wrap that quickly, and then the last two subjects of the day, we're going to talk about contract transparency and lock-in. On the pretrial reform, just for those in the public who are not familiar with it, The idea here is that a significant portion of the jail population are people that are sitting in there for low-level nonviolent crimes that simply couldn't afford the bail. So the people that can pay $50 to get out, they're able to pay. That says nothing about their innocence or guilt, right? They just could pay the bail. But if you're houseless and you're sitting in jail, even $50 bail becomes unaffordable. And many sit in jail for months and even over a year just because of that bail, again, for low-level nonviolent crime. So the idea is that if you got rid of the bail requirement, they could await trial in a community-based setting, like a group home or a mental health facility or a treatment center. And this year, a bill that would have allowed a number of nonviolent low-level offenders out, it passed the House up here, and it passed through 2 committees in the Senate, made it to the Senate floor, and ultimately on a split vote failed, but it came very close to passing. And just to wrap this up, the point is that we will have pretrial reform in Hawaii in the next handful of years. It will happen. And then that will significantly reduce the jail population. So again, this brings us back to what is the proper solution for OCCC, understanding these things are coming down the road, and also acknowledging the constraints of the state that, that's just how government operates. They got to look at today. What does it look like today? But we might be building something today based on yesterday's assumptions. So that's the idea. Let's turn to a different topic. Eric and Jim, I want to hear from you about the contract. These P3 contracts are hundreds of pages long. They're partially shielded as proprietary. How can lawmakers and the public meaningfully evaluate whether this is a good deal?
They can't.
Okay. Jim?
Yeah, as I said at the outset, it's difficult to know precisely what they're doing to save money and how much profit they're making. We can see maybe what they're obligated to do in the specifications. I'm not sure which parts of it are going to be open to the public, but yeah, it's going to be at least partially clouded from the public.
Yeah, because one of the things you said that stood out today, Jim, was that the outcomes of P3 partnerships really partially rest on how good the contract is, to put it in layman's terms. Right. So that's helpful. Sorry, Carrie Ann, do you want to add something?
Yes, I think we need to look through, again, some actual examples. So in the state of Alabama, the Governor Ivey pursued a P3 project. And I'm going to be quoting a little bit because I want to make sure I get their words accurate. Republican governor, they were proposing to design, finance, build, and maintain 2 new prisons and lease them to the Alabama Department of Corrections with state employees. Sounds familiar. In soliciting and screening potential private partners, the governor's administration promised that, quote, any information received in response to the solicitation requests will not be publicly available until financial contract has received all approvals. The negotiations that continued thereafter were confidential, and Senator Representative Rich Ringo, a Republican, complained about the secret negotiations and said that at the very least, the legislature was entitled to know the developer's profit margin, and that was not available. Another Republican, Representative Arnold Mooney, said that lawmakers were kept in the dark and asked rhetorically how they could carry out their fiduciary responsibilities to protect taxpayers without knowing anything about the P3 contracts or the costs of the prisons. And it goes on about the integrity. Lawmakers were in the dark. And my understanding is that this ultimately failed because the financial backers pulled out of the deal. And they ultimately ended up pursuing, I believe, bonding, sort of the traditional method. But this is an example that even in that state, lawmakers who have some oversight in footing the bill, and all of us had no access because they were claiming proprietary, that it's confidential. If it's taxpayer dollars, it should not be confidential.
Great. And before we go to questions, two quick questions. One is, from a policy lock-in, does this type of long-term contract, especially in the correction center, make it harder to reduce? Does it make it harder to reduce incarceration over time, or has any jurisdiction successfully downsized or repurposed, you know, a P3 jail mid-contract without major financial penalties? I mean, what sort of flexibility do we have here?
Well, my understanding is, you know, it seems logical that the state's going to be obligated to pay them back for the design and construction. And that's the majority of the expense over the 30 years. So that's pretty much locked in. You'd be looking at what else can we do with these buildings really after that. And, you know, jails are pretty specific buildings, not easily repurposed. So.
Good. Thank you. And then final question in one word, should certain private companies such as CoreCivic, which are currently lobbying the legislature on the new jail contract, but have faced significant lawsuits over the facilities they operate and maintain, including ICE detention facilities, should those companies be disqualified? Eric?
Well, I mean, I don't know the answer to that. Obviously, if they're not qualified and they have not fulfilled their obligations elsewhere, that's certainly something that ought to be taken into account. So, I mean, I wouldn't, in my own affairs, contract with somebody who presents themselves under those kinds of circumstances. But, you know, I don't know what the state is going to do or will do. You know, the problem here, in my view, as I said earlier, is the state gets bad legal advice on these matters. That's where a lot of the problems lie. You know, Mr. Johnsel's not a lawyer, but he relies upon these AGs who come in and give opinions and don't know what they're talking about. And I can document that up one side and down the other, and particularly under this present Attorney General. So that's the problem that you face. You're going to contract with something that's going to tie up the state or some agency for many years or decades to come based on the legal advice of these attorney generals. Horrible idea.
Thank you. Carrie Ann and Jim, I'm guessing you would feel certain contractors should be disqualified outright?
Yes, absolutely. I think that we should look at the track record of CoreCivic, how our people have been treated in not only Arizona, but a number of states from Tennessee to Mississippi, where we've shipped and exported our people over the years. We should look at their track record of their detention centers for immigrants. We can all see the little image of that little boy with his backpack and bunny. That facility is run and operated and controlled by CoreCivic. We have had conflicts of interest. A number of governmental officials from past administrations have been lobbyists for CoreCivic, all the way up to even a prior attorney general in Hawaii and the Department Budget and Finance Director, who have been lobbyists for CoreCivic. And CoreCivic lobbyists do not testify in front of the community in public hearings, closed-door conversations. So the lack of transparency is already there. They attend meetings for the Oversight Commission when this jail proposal is being pitched. We have governmental officials going to conferences in Tennessee and having sort of, I would say, meet and greet to pitch building a new jail. And we also have subcontractors who've been involved with the planning, including Louis Berger, that they were convicted of fraudulent activity and fraud at the highest levels, and yet Architects Hawaii hired them. And when they were called upon to answer to the questionable, should we be subcontracting with these subconsultants, their response, Architects Hawaii, is that proprietary, it's confidential, we have contracts with our sub-grantees. This is taxpayer dollars. And I just want to add that we need to look at our future, that at one point in time, Hawaii was at a similar crossroads with our juvenile justice system. It was overcrowded, there was abuse, there was an investigation by ACLU Hawaii and the Department of Justice, lawsuit, consent decree. We could have easily built a bigger prison for our youth, but community members, and with the support of Judge Browning, came together and invested in best practices. We have successfully decarcerated the number of youth. We focus on real trauma-informed care for keiki and their ohana. And think about, we could have built that. And we actually achieved 0 girls in our juvenile justice system. And we have maintained that to the point that other national organizations and states are looking to Hawaii as a model of best practice. So if we apply that discipline and political will to invest in evidence-based strategies, we can successfully decarcerate, and we will not have to invest in building a new jail because if you build them, you will fill them. And that's kanaka maoli in future generations. And for many of us, we care about our community and not on our watch.
Great. Thank you. With just a couple minutes left, I want to give opportunity for any questions.
Liam, we do have a few questions that have come in from Zoom.
Okay.
So I'll just pose those. Let's see.
And are we at liberty to take an extra 5 minutes for this, or we have a hard stop?
Yes, as
great.
long as everyone
Great.
is okay
Important
with that.
conversation here. Thank you.
Okay, so one question is, how can the state ensure that the P3 will implement recommendations given under the UH report for the proposed
Great
jail?
question that came up earlier. Anybody want to take that on?
So is there a way to ensure that the recommendations will be followed or not?
No. Under the statute, there's nothing that's mandating the department. It's advisory. They paid for it, but they could also ignore it.
Jim, do you have anything to add to that? Okay. Any other questions?
Yes. Follow up to that is, how could OCCC be improved? Is that being looked into instead of a whole new facility being built?
I can speak to that. I think that I've heard from DCR and the state that just there are areas of the jail that are so old that they just simply cannot be renovated. Some of it's over 100 years old. To our knowledge, no official study has been done that concluded that that was publicly available, but that is what's being said by the Department of Corrections. I think what some of the folks that are concerned about it have said is that you could potentially build a smaller facility at the same site. You don't have to try to renovate the older areas. You could let those go, demolish them and kind of rebuild parts of it. But again, I think all conjecture aside, without some sort of official study to look at about what can be renovated and what can't be, it's sort of hard to say.
I just want to add, at any point in time, we can improve our correctional system, including OCCC. And one way to do that is to shift sort of our model. The department has been renamed Department of Corrections and Rehabilitation. And this was 20 plus years ago. I was the director of a Maui Economic Opportunity, and we partnered with the Department of Public Safety then, now Corrections, community providers, mental health, substance abuse treatment providers, and we had case managers from our nonprofit that we worked with the wardens and with the head of probation and parole so that our staff members taught classes from pre-employment training to cultural classes. So it's called a reach-in model. We could do that today and have community-based organizations that are willing to go into any of our jails, of course, with the cooperation with the department, and provide those services, because we recognize that there is a severe understaffing and it's difficult on staff. And so by having outside community organizations, state departments go in, it is a win-win for the department, for the state, for people. And that doesn't require, a new constructing $1 billion jail. That requires just a willingness to collaborate for what's best for our community.
I think that's an important point, that when we talk about improving OCCC, as the Hawaii Correctional System Oversight Commission in their letter to the governor calling for a pause noted that the facility itself, the physical conditions, obviously limit programming. It's very difficult when you have a facility that's falling apart and is too small and so forth to have ideal programming, but it doesn't totally absolve it, right? There are still more things that could be done, and that was what the letter pointed out. That it's a both situation. It's both upgraded facilities, but also the programming itself has to be improved. Any other questions?
Yeah, two more questions. This one concerns the proposed location. Does the Department of Corrections and Rehabilitation own the property at the animal quarantine station? Department of Ag did not get funding to move the animal quarantine station, so it seems after the millions of taxpayer funds that contractors have received, they didn't do their due diligence. And then maybe if you could speak to on the other proposed location for the new jail, where that would go.
Anybody have an answer to that?
My understanding is that the land underneath the current animal quarantine, that it is owned by the state. So it's the state still as the owner. But I would like to speak to this issue about location, because I know it's being pitched that Halava is a very beautiful, sacred place. But I also have very real concerns about using language of building a new jail to lock up more Native Hawaiians, Kanaka Maoli, in a cultural sacred space, when we should be diverting them so that they're in the sacred space with their ohana in community. And so I find that completely offensive. But I would like to say, from a reentry perspective, having worked for a reintegration program that was very successful, and there was a third-party study to show that participants in our program had lower recidivism rates with comprehensive support, is that to be in a hub in a community where there's more access to transportation, jobs, other training, that's more of an ideal placement, in my opinion. And if you know anything about Maui and Wailuku, Maui Economic Opportunity was right across from, other places in the hub, by the hospital. The court wasn't very far away. And so I think that this idea of you need to move it, I don't think it's optimal for reintegration.
Okay, great. I want to honor the time and people's day. So I think we're gonna close there. I just want to close with a couple of things. One is that this discussion needs to continue. I think that considering the soonest it would open is 6 years, that's actually a long time. And knowing Hawaii and the way we build things here, that's probably not going to happen. So at the same time, we need to say this again. Everybody agrees the current conditions are completely unacceptable. No human being should be subjected to the conditions of no CCC. So from a narrow perspective, DCR's concerns are absolutely understandable. At the same time, we have to come to the right solution, and diversion and bail reform could happen very immediately, not in 6 years, but immediately. So let's continue the conversation. But lastly, I just want to thank everybody here on this panel. Can we all give a hand for these panelists? We look forward to continuing this discussion and debate on behalf of the people of the great state of Hawaii. Mahalo, everybody.